Madam, item 42.
Clear for adjournment, please tell Ms. Verma and then tell the court master.
At 2 p.m. Like said, there's a
At
correction.
2 p.m.
2 p.m.
Item number
42.
42.
41 malagi.
Only minute to incorporate the minute case number.
25.
Other is not figure.
25.
Okay.
At 2 p.m.
Next, that's to mention here, item number 46 and connected matters, Lordship. Yesterday, this matter was there, Lordship, that criminal appeal, your Lordship has also had on bail point. So can it be taken up at 2, Lordship? I have talked with PP, Lordship, that Mr. Dhanesh Das, Lordship, he also agreed if it can be taken up at 2, Lordship.
Okay.
May I please your lordship, I beg to mention for item 22. Lordship, my senior is in medicals, so kind of.
Lordship, there's only one item where Lordship may need to pass order. That is item 41. The Ghosh is appearing. It would not be before Lordship.
That's it. 41. This is the matter before any other bench without one of us. Yes, Ramaji.
Daily list item 1 for withdrawal.
The matter is in fact, sir, because they already he's been released from the detention camp.
He's released. On instructions, Mr. P. Mahanta Ranad, counsel for the petitioner, has submitted that during the pendency of this matter, the petitioner has been released from the detention center, and accordingly, the matter has become infructuous. Mr. P. Sharma Ranad, government advocate, appearing for respondent numbers 3, 5, 6, 7, 8, and 9. And Ms. P. Fukan,
K. Fukan.
K. Fukan Leonard, CGC, representing respondent number 1 and 2 are present. Matter stands closed as it has become infructuous.
Item 2 for motion.
Lordship, we have instructions in this matter, Lordship.
Yes.
Regarding proceedings at 2 cases, Lordship, I have placed these instructions. We have it from Jorhat also, Nagaon also, Lordship.
Bring to you.
You can do it.
Delay.
What is the effect of this, Jorhat?
It was a link condition.
Notice at page 19, my lord, page 19.
It is still pending, lordship.
No, there are two matters in Jorhat.
No, no, my lord.
One in Jorhat, one in Nagaon, lordship.
My lord. In Jorhat, my lord, in the WS, the case number is wrongly mentioned, my lord.
There was,
My lord, that is fault on the part of the
They-
advocate, my lord.
No, but that's okay. But the other fact is that the proceeding in that Jorat case
yes, lord.
is Nurul Islam, not Abul Kashem Ali.
That was wrongly, it is informed that the case, lordship would kindly come, was registered in the name of Muhammad Nurul Islam, son of Rustam Ali, lordship. And
Not Abul Kashem Ali.
not, yes, lordship.
So that means he is not the proceeding there.
So there are two different,
Oh, my lord, kindly come to page 19, my lord.
Page 19.
My lord. SBR 208, my lord, 2009. That is against the petitioner, my lord. In the WS, in Jorhat case, my lord, the 1420 of 2004, my lord, that is wrongly written. That is, my lord, fault on the part of the learned advocate, my lord.
No.
Actually,
The instruction says that the case is against 1420 of 2009,
That is not against the petitioner, my lord.
not against the
Yes,
petitioner.
my lord. 208, my lord, of 2009, that is against the petitioner in Jorhat. And another proceeding in Nagaon, my lord.
No, you are, on the last date, you were projecting that you are proceeding in two cases,
Two cases, my lord.
but you are not.
No, only two cases are there, my lord, not three cases, my lord. That the case number
No.
120,
No, in that proceedings of Jorhat, where is that document?
that is at page, my lord, 19, the notice. At page 19, the notice of Jorhat. But next page, my lord, page 20.
Jorhat ওটা আপনি কাম কৰিব গৈছিল। নগাঁও আপোনাৰ permanent ঘৰ। এইটো কথা ঘৰত বুজিব আগত এতিয়াকে বস্তুটো clear হ'ব। Lordship, he has two proceedings. Jorhat, he went to work, he could not submit documents, so a reference was filed against him. Again, he shifted back to Nagaon. And there also, on the basis of the inquiry report, he could not produce any documents,
No,
lordship.
you see, as per this instruction at page 2,
Yes, lordship.
there is two proceeding against him. One is 208
Yes,
or
lord.
09.
Yes,
This is the first paragraph.
yes,
This is the
lordship.
case of Abul Kashim, correct?
Yes, my lord.
That is page 18.
Yes, lordship.
Now page 20 is FC SCR of Jorhat. 1420. This is Abul Kashem.
My lord, his number is written wrongly, my lord.
And
That is
the
number
one at page
1420.
20, the
Yes,
one
my
at
lord.
page 20 is wrongly
That is,
written.
I am saying, my lord,
Page
the
20, the error is in the name or in the number?
number only, 1420, my lord. It is written 1420 instead of, my lord, 208.
Okay.
That is it, lordship. And the member has clarified that it was wrongly written by the learned lawyer, lordship. So he has two proceedings against him, one in Jorhat, one in Nagaon,
So then
lordship.
earlier in point of time shall prevail.
Yes, no, lordship, and his prayer is for transfer, and which cannot be.
No, it's not a question of transfer, but here is a circumstances where we have to do it. You see, it's not a question of transfer. It will be a case of merger or two cases into one.
Yes, my lord.
And then it will be proceeded with.
One place, my lord. Either in Nagaon or
Lordship,
Jorhat.
My humble submission is let this first proceeding be completed, and then he will go in because he's filed his WS in both the proceedings, lordship. he is,
One can't be subjected to a proceeding twice. That hits Article 20.
Lordship will,
Even if we don't go there.
another thing is Lordship, his father's
It
name
cannot
is
be
different
done
in
this
both.
way.
One is, if Lordship will see in
Hasmat
one, his
Ali.
father's name is Muhammad Hasmat Ali, and in the second, it's Abdul Qasim Ali. So whether he is one and the same person who is
Yeah, Abul Qasim Ali is his own name.
no, Lordship, Abdul Qasim Ali, yes, and
He has alias.
Qasim,
son of Muhammad Hasmat Ali,
Mohammad Hasmat Ali and Hasmat Ali.
Hasmat Ali. This is in Nagaon, Lordship, but in Jorhat.
Jorhat
Mohammad
also
Hasmat
Hasmat Ali.
Hasmat Ali.
Yes, Lordship. Lordship, I would like to refer to that judgment also, which has been very recently passed regarding transfer, Lordship. Lordship, I have
It's-
requested them
No,
to
it's
give a
there,
copy.
we have the book.
Yes, Lordship,
We have the book. It's in GLT, June GLT.
yes. Only in exceptional circumstances, it can be
How can two
transferred.
proceedings be allowed to proceed?
One can be kept in abeyance, Lordship. The first one which started, let him complete that one, and then he can, with the opinion of this one, if it goes in his favor or for the state, he can go and contest the other one at Jorhat Lordship.
What is the point of giving it in abeyance? If there is a doubt that whether he is one and the same person, then it's a different issue. That these two proceedings are not against the same person, against two different persons. But if from the instructions which you have placed
Yes, Lordship.
from Jorhat, it appears to be against
The
this
same person.
Same person. And as well as in Nagaon. So Nagaon started earlier. in
Your
49.
Lordship.
So it may appear in Nagaon. This, we close it. Whatever will be the outcome of Nagaon, we'll abide by it. What is the point in keeping Jorhat otherwise?
There's no point in keeping Lordship.
Unless you say that no, there is a doubt whether it is one and the same person. If it is against another person having similar name, then of course, that instructions you'll have to give us. Assuming it is against some other person, even then it is to be kept in a range.
Yes, Lordship. Lordship may decide it as Lordship deems fit, Lordship. Lordship, there's just another aspect. There are many cases as such where proceeding has two or more than two proceedings against him because of change of address, and wherever they go, a reference has been drawn. So allowing one will open the floodgate to all the other cases, Lordship.
That's what we are discussing.
And that was the reason why this transfer matter was taken up by the larger bench. The prayer may be something different to amalgate or to bring it to one district, but basically it is transferring the matter from one district to another district, Lordship.
No, those are cases where he was in one particular district, proceeding started in another district. Therefore, he came and said, now he's in this district, proceeding should be transferred. The court rejected.
That is the common modus operandi which goes on from Dhubri to Morigaon to Ojai,
Correct.
Jorhat, Lordship.
But here is a case where the proceeding, the current,
We have faced like these matters earlier also.
what orders were passed?
This was Justice Bhuiya would always keep one in abeyance, ask them to appear in the first one which is going on, and then take that opinion and go and show it to the for the second proceeding, whatever is the outcome.
We are also thinking the same.
No, but we are thinking beyond.
Yes, Lord.
You see, even if an opinion is rendered, the second tribunal will have to take up a proceeding and find out if they are same person or different person.
Yes.
So for some time, the proceeding will have to be exposed to a second proceeding. At least the second tribunal will have to record a satisfaction that the proceeding is the same person who has been subjected to proceeding at Nagaon.
Nagaon, Lordship.
Because otherwise, two people may be having same names.
Yes, that is very common, Lordship. Or if two different persons are having two different proceedings, Lordship, but before this court, they may look like one.
What we propose to do is the first proceeding which started in earlier point in time, that is Nagaon. He will go and appear in Nagaon and contest the proceedings. Jorhat will keep it pending. The outcome of which will be determined on the basis of what orders are passed after in Nagaon.
For the time being, that can be kept pending, Lordship.
Yes,
Yes, my lord.
but. Schedule before this court. Yes. The same proceedings.
I'm not a open asset. Resolution के साथ देखा हो तो opinion render करेगा.
For so and so FD so and so 208 pending before that's right. Sorry, yes. Prayed for transferring of the proceedings pending against the petitioner. FD so and so 208 of 2009 from Jorhat for foreigners tribunal Jorhat, the foreigners tribunal number 1 Nagaon, where another case being FD case number 14 of 2016 is presently pending against the petitioner, and to amalgamate both the cases. So, by order dated 29/7/2024, this court permitted the respondents to obtain the instructions of both the tribunals. the instructions received by the respondent councils are placed before the court. So, the instructions received from the Foreigners Tribunal, Nagaon first reveals that the matter is presently pending at the stage of examination of official witnesses. So, the written statement and evidence or affidavit has also been filed, and the witnesses have also been cross-examined. Next date fixed is 27/8/2024 for official witness. Yeah. So far as instructions which have been received from Foreigners Tribunal Jorhat, it is seen that the FT case number 08 of 2009 is pending, where written statement and written evidence have been filed. Stop. Another case, which is FTSVR 1420 of 2004, was seen to be reflected in the where in your written statement.
That is, my lord, 1420 of 2000.
Where was it reflected?
That is, my lord, page 20.
In the written statement.
The written.
Filed before the court. So tribunal has clarified that this number FTSVR 1420 of 2004 was wrongly reflected in the written statement filed on behalf of the petitioner in connection to case number FTSVR 208 of 2009. Stop. Tribunal has clarified that the case number FTSVR 1420 of 2004 was registered in the name of MD Nurul Islam, son of MD Rustam Ali, resident of T Nazira, Post Office, Police Station Nazira, District 6, Assam. And the same matter was disposed of on 26/03/2024. So, there are. Having noticed the instructions that are placed before the court, we see that presently there are two matters pending against the writ petitioner. Namely,
Abul Qasim.
namely FT case number 14 of 2016 before the Foreigners Tribunal first, and FT case number FTSVR 08 of 2009, presently pending before Foreigners Tribunal. So, upon hearing the counsels for the parties and upon consideration of the instructions placed before the court, as well as upon the result of the pleadings available on the court, as court is of the view that the prayer for transfer sought for by the petitioner cannot be granted at this stage. So, since the Foreigners Tribunal, since the case pending before Foreigners Tribunal first was instituted at an earlier point in time, this court is of the view that the same proceeding should be allowed. They continued against the writ petitioner. Stop. The writ petitioner has already entered appearance before in the same proceedings before the same tribunal, and the next date fixed in the matter is 27/08/2024. Stop. The proceedings will be decided by the FT first, in terms of the procedure prescribed by law, and any opinion that is rendered by the proceedings will thereafter be placed by the petitioner before the Jorhat Tribunal in which FTSVR, in which case number FTSVR 208 of 2009 stated to be instituted also against the petitioner is presently pending. So till the time the proceedings in FT case bearing number 14 of 2016 pending before the Foreigners Tribunal first Nagaon is decided by the tribunal command. The proceedings pending before Jorhat in case number FTSVR 208 of 2009 instituted against the petition shall not be proceeded with and be kept in abeyance. So the opinion that may be rendered by the Nagaon First Tribunal in case number FT 14 of 2016 will be placed before the Jorhat Tribunal, and thereafter Jorhat Tribunal will pass necessary orders in terms of the in terms of law. So their petition is disposed of with the above directions. So, however, petitioner is permitted to file necessary applications for leave to modify or vacate the order by which the proceedings before Jorhat have been kept in abeyance till disposal of the proceedings pending before Nagaon First Tribunal. So this application can be moved by the petitioner only after the rendition of the opinion by the Nagaon First Tribunal. The petition in terms of the above stands closed. Dispose of interim orders pending stand.
Obliged. দুটা এটা সেই ওপৰত আছে আৰু এটা 42
Yes, next.
Item 3.
Yes. One two nine six. Exactly.
Yes. My lord, impugned order, my lord, page number 30. And the grandfather's 1965 voter list, page number 39, 70, page number 41.
You come to the appreciation of the evidence
My lord,
by the tribunal.
my lord.
Perhaps from page number 35.
Page number 35, my lord. My lord.
Exhibit 1.
Yes, please proceed.
My lord, may I read?
Yes.
Hard argument from both parties and gone through the reference made by the SP Border Nagaon. As per observation of Honorable Guwahati High Court, it's right, and that mere filing of written statement and oral testimony in proceeding under Foreigners Act would not be enough. The fact in issue would be to have to prove by the proceedee by adducing documentary evidence which are admissible and relevant. Proceeding to the evidence and documents submitted by the proceedee, it is seen that there is a link proceeded to his projected father in exhibit number 1 and exhibit number 6. Exhibit number 1 is the school certificate by the headmistress of Pragjyoti Balika Prathamik Vidyalaya, certified that Eliza Begum, daughter of Muhammad Abu Bakr Siddiq, mother Jeleka Khatun, village Futal Jar, police station Rukuihat, subdivision Nagaon, district Nagaon, residing in Pragjyoti Balika Prathamik Vidyalaya. She left the school on dated 31/12/1991. She had passed the annual examination of class 4, character good. According to the admission register, her date of birth is 2/1/1982. In the certificate, the state emblem of India is embossed at the top. As per the state emblem of India regulation use rules 2007 framed by the central government, it is evident that headmaster of a primary school is not authorized to use state emblem of India in any certificate issued by the said authority. This itself makes this document inadmissible in evidence. That apart, this document itself is full of contradiction. Moreover, one important point is that the proceedee left school on 31/12/1991 after passing class 4, and this certificate was issued on 26/5/2016. 25 years thereafter, and at that time of the cross-examination of school headmaster deposed that she changed her name from Begum instead of Eliza Khatun in the admission register. Exhibit 2 is a Gavura certificate issued by the government Gavura of village Futaljar. The Gavura certificate certified that Muhammad Eliza Begum, daughter of Abu Bakr Siddiq, village Futaljar, post office Futaljar, Moza, Sadaria, police station Rukuihat, district Nagaon, Assam. The above mentioned woman was permanently resident of above mentioned village. He know him very well. The above mentioned woman got married with Muhammad Muntaz Ali, son of A. Sattar of village Kachari Gao, Moza, Juria, Piaz, Juria, district Nagaon. It is noticed that the state emblem of India is embossed at the top of the certificate issued by the Gavura under Schedule 1 of the State Emblem of India Regulation of Use Rules 2007, framed under Section 11 of the State Emblem of India Prohibition of Proper Use Act 2005. The Gavura is not an authorized authority to use the state emblem in a certificate issued by him in any manner. Such unauthorized use of the state emblem of India would render the certificate issued by the Gavura not only inadmissible in evidence but also untenable. Proceedee's other exhibited documents are Exhibit 2, certified copy of the voter list of the year 1965 of village Futaljar, Moza, Sadaria, police station Rukoihat, district Nagaon, wherein serial number 364, house number 95, Sahid Ali Mondal, Zaharuddin, age 75, serial number 365, Hafizuddin, Sahed, age 42 are voters. Exhibit 3 is a voter list, is a certified copy of for the year of voter list for the year 1970. 87 number Rukoihat LSC of village Futaljar, Moza, Sadaria, yes, Rukoihat, district Nagaon, wherein serial number 364, house number 95, Sahid Ali Zaharuddin, age 85, serial number 365, house number 95, Hafizuddin, Sahed, age 47 are voters. Next page, Mila.
What is the linkage document?
My lord, linkage is this Gavura certificate and the school. Both of them, Lord, deposed.
How can you depose when the certificate itself is not visible?
My lord, it is only that national emblem, my lord.
Whatever it is not acceptable. There are orders of this court.
My lord, these are
You depose in respect to the contents of
My lord.
something.
my lord.
This is a document.
My lord.
The document in the first instance is not even admissible. What are you deposing about?
My lord, if I may take your lordship through the deposition of the headmistress, my lord, because there is already register she has maintained since 1991, my lord.
See, you depose in respect of what?
Respect of the
authenticity
certificate,
of some document.
my lord.
The document itself is not admissible, held to be admissible.
My lord, there is a judgment of this honorable court. I am not in possession of it today, my lord. Some other day, my lord, I will submit that judgment, my lord, of this honorable court where there is discussion about this this emblem, that it does not completely nullify the entire document, my lord. And it also doesn't take away the fact that this person is the daughter of Abu Bakr Siddiq, my lord.
Where is the deposition of the headmistress?
Headmistress, my lord, page number 65, my lord. Page number 65, my lord. Because there is back-end document, my lord. At this stage, I am only, my lord, praying for interim bail, my lord. But page number 65, my lord, headmistress, my lord.
We'll give you orders on the day you produce the judgment. You said some other day
Can I
you
read
want to
the judge?
produce a judgment.
My lord, I will just read this deposition, my lord. My lord, page number 65, my lord. I have been summoned to appear in the case. Exhibit 1 submitted in the instant case was issued by me. The certificate bears serial number 12 and issued on 26/5/2016. The certificate was taken by the proceedings mother from the school. The mother's name was Jeleka Khatun. Proceedings name is Elijah Begum. Her father name is Abu Bakr Siddiq. According to the certificate, they are resident of Pufutaljar. According to the certificate, the applicant left school on 31st December 1991. As mentioned in the certificate, the proceedee passed class 4. Today, I brought the school admission register book with me. According to the admission register, the proceedee's name was in serial number 135. The applicant was admitted in class 1 on 2/4/1987. In the cross, my lord. Our school was provincialized in 2013. I joined the school in 1980. I am the founder of the founder headmistress of the school since its inception. Eliza Begum is the daughter of my brother-in-law. Her name is mentioned in the admission register as Eliza Begum instead of Eliza Khatun. Eliza's father is still alive. I brought the book record of this certificate. Eliza left the school in 1991. In the year 1991, the certificate was issued in the year 2016. I proved the certificate as it was needed for the aforementioned case. The Ashok Chakra is provided in the top of the certificate. It is not a fact that Elijah Begum was not the student of our school. It is not a fact that I have given false statement since Elijah Begum is our relative. Not there is register in it was also before the learned tribunal, my lord. So at
Now,
least
now you studied up to which class?
class 4, my lord.
Class 4.
My lord.
Now come to page 74.
My lord.
This is the proceeding.
My lord.
See the first line of deposition.
I do not know how to read and write. I can put my signature. I studied till class 4.
Then
My lord.
what is the name of the headmaster?
The name of the headmaster is Ramisha Khatun, my lord.
Then 75,
My lord.
name of the headmaster is something else.
My lord. This is what she inadvertently made, my lord.
Evidence.
My lord. But my lord, the record doesn't lie, my lord. The record says that she was admitted to the school and the registers were there before the learned tribunal. Enter him at this point, my lord. Examine later on, my lord.
Yes. Respondents. Propose to call for the records.
Yes,
Right.
Lord. Sure.
Examine the records and then. Cite. Third, councilors. Petitioner is agreed. I. The opinion rendered. dated 12/1/2023 in FT case number 33 of 2016 by the member Foreigners Tribunal Fourth Count, whereby petitioner has been declared to be a foreigner what?
Post 1971.
Where?
This is page number, my lord. The reference does stand disposed of on the contest in terms of the above discussion about in result proceeding declared as a foreigner. Specifically,
Declared to be a foreigner in terms of the reference. We submitted that the petitioner presented sufficient evidence and witnesses before the tribunal. However, the same will not consider the proper perspective, and consequently the opinion was rendered declaring the petitioner to be a foreigner in terms of the reference. Being agreed, the present petition has been filed. Before issuing notice, the court proposes to examine the reports. With the reports in connection with FT case numbers from FT fourth Nogao, the requisition by the ministry. Meanwhile, the petitioner will appear before the ASP holder Nogao within a period of 10 days from today. And upon furnishing a bail bond of ₹5,000, be permitted to remain on bail and shall not be detained in custody or deported out of the country. Like the petitioner appears before the ASP holder, her biometrics and fingerprints and photographs and other particulars, including telephone numbers, be recorded by the SP. Let the matter be listed after the receipt of the foreigners tribunal reports. Extra copies be furnished to the respondent
My lord.
counsels
My lord.
in the course of this week.
my lord. I'm deeply grateful, Mr.
Listed.
Deeply grateful.
Item 4.
Please, your lordship. My lord, the impugned order at page 72, lordship. It's an expert order, your lordship. Page 72.
Why you didn't appear?
Lordship, on the first occasion, I appeared and submitted WS, lordship. Thereafter, I could not appear, and I was not properly instructed also to appear before the learned tribunal, and consequently,
Up to the notification. The question, please.
This is approaching the court after 10 years. Which part of the shop? You want that now? Sakina Khatmi. Expert judgment and all this.
one more thing is that I think this must go back to the registry. Your affidavit does not disclose the phone number even after the notification.
No, it was number 2. Very
Oh, acha. Yes. Okay, missed it. Okay, correct. Yes,
Page 72. Page 72 is the impugned ex parte order.
page number
72.
72.
After receiving notice, I appeared before the learned tribunal and filed WS lordship.
So
Thereafter,
right, 2014, there, you have
Yes.
come here after 10 years.
yes, lordship, there is delay lordship. As it's an ex parte order, I was not aware
You're
of,
in custody.
no lordship, I'm not in custody.
What is going on? There is a clear opinion by the tribunal.
Yes, lordship.
You should take it up with the Home Department. What is going on? 2014 order,
14 order, lordship.
10 years,
10
sorry,
years,
10 years,
10
yes.
years, lordship.
What is the point in undertaking these exercises if the government is not willing to carry it to the logical end? At least you should make an inquiry why the
Why
SP was not,
Lordship will do that.
or was it not brought to the notice of the SP for some reason?
We can get that
Lordship.
instruction, lordship. And we ought to get, because it's a,
You must inform them that once the
Yes.
orders are passed, they must take the proper steps as per law.
Lordship may kindly see page 61, this is the notice and Indian.
it's really embarrassing. Very embarrassing.
The notice lordship, I was doubted as.
Force. Yes, respondent. I've come to page number 62 or
Yes.
61
Yes,
in
Lord.
the English translation. This is the notice. And see the
1166. 1166 and 25,371. Para 1.
between.
That is the format, lordship. It always,
No, that's okay.
yes,
But
lordship.
the opinion page 72.
Page 72.
Last line.
Post 71. Lordship, had the petitioner appeared with her documents, it would have been, the opinion would have been more specific and detailed, Lordship.
Proceeding is for declaring
Between.
and the opinion is
Post.
post.
Lordship, this between thing, Lordship, as per Foreigners Act, we have entered within 66 to 71. This is a normal format. Some from some tribunals it goes on or before, Lordship, or in between. The stream can be determined only after they submit their documents and on the basis of that,
Quite
Lordship.
right. What we are saying is this is ex parte.
Yes,
Because both has different consequences.
consequences.
Both will have different consequences. That was the reason for pointing it out. Heard learned counsel for the parties. The petitioner is put to challenge the opinion dated so and so, passed in FT case number so and so by the Foreigners Tribunal within bracket third Dorong Mongoldoi, whereby the petitioner was declared as a foreigner of the stream of post 25/3/1971. The said order, said opinion was passed ex parte. Petitioner submits that you filed WS.
Lordship, I filed the application.
He filed WS, but subsequently, because of reasons beyond his control, beyond her control, the petitioner could not appear. So at this stage, this court would like to examine the tribunal records and accordingly let the records, tribunal record pertaining to FT3 case number 190 of 2012 from the Foreigners Tribunal third Dorong Mongoldoi, the requisition by the registry. Meanwhile, the petitioner will appear before the SP border
Dorong Lordship.
Dorong within a period of 10 days from today. And the biometrics and fingerprints, photographs, etc. be recorded. And if the petitioner furnishes a bail bond of 5,000, petitioner shall be permitted to be enlarged on bail and shall not be arrested or deported out of the country until further orders from this court. Matter be listed upon receipt of the tribunal records. The respondent counsels be served with sufficient extra copies within the course of this week by Friday.
Obliged, Lordship.
So then he has to register and for 10 years, after 10 years, he get all benefits.
Item 5.
May please, your lordship. Lordship, in this case, the petitioner declared foreigner post of 71 lordship. Petitioner submit the voter list of 1966.
How
Father-
have you connected yourself to your parents?
Connected, my lord, a Jawamund copy, my lord, Annex of 12, my lord, is 33, my lord.
Which page is the opinion?
Opinion, my lord,
5.
is 80, my lord.
Page
80.
80.
80.
What is that 52?
My lord, my sister declared Indian, my lord.
Oh,
This is the opinion.
Who is this proceeding?
Proceeding, my lord, Musabot, Ajuba Khatun.
No, this page 52, who is this proceeding?
My lord, sister of the proceeding, my lord.
Sister.
Yes, my lord.
This
या तेरे को लिखाना है Yes, Lordship.
In this case, page 52,
Yes, Lordship.
this opinion is standing or it has been recalled?
It is not a reasoned opinion, Lordship. I've just seen it. I'll have to take instructions on this, Lordship.
Because you have that list,
Yes,
you
Lord.
have that list of orders which have been recalled.
We have it maybe in the chamber, Lordship. We'll check it up.
Where is your land document?
Land document, my lord, page 33. Exhibit 12.
Page?
33.
Where is a copy of the death certificate of your father?
No, my lord.
It's not there.
No.
In which year he died?
My lord, it is not mentioned, my lord. When the father of the petitioner died, my lord.
Who is the petitioner? The complete कोई डिबा दे कॉपी नहीं नेक्स्ट टाइम पर मैं कोई नहीं और ये बिला को फुल नंबर नहीं कर because the recordation
During the first window.
to listen to
W सो रखो पे मंजरी वैसे
Provided their system. Provided their system. Let us call for the records. Heard the council parties. Petitioner is aggrieved by the opinion dated 24/08/2023. Passed in case number FT 702 of 2012 by the Foreigners Tribunal -1, Tezpur, Assam, whereby petitioner was declared to be a foreigner of post 25/03/1971. Stop. According to the learned counsel for the petitioner, the evidences produced before the tribunal were not considered appropriately by the tribunal, and thereby petitioner was declared as a foreigner. So it is also submitted that by an earlier order passed by order dated 18/12/2012, passed by Member Foreigners Tribunal Sonitpur in FT case number 45 of 2012, one Mosammed Kamala Khatun was declared not to be a foreigner. Stop. The said Kamala Khatun, the petitioner claims that the said Kamala Khatun is a sister. Para be it as it may, this court would like to examine the tribunal reports. Stop. Registry is therefore directed to requisition the tribunal records from Foreigners Tribunal -1 Tejpur in connection with the case number FT 702 of 2012. Stop. Meanwhile, petitioner will appear before the SP order Sunitpur within 10 days from today. The SP border will record the biometrics, fingerprints, and obtain her telephone numbers, photographs, etc. And if the petitioner furnishes a bail bond of ₹5,000, the petitioner will be allowed to remain on bail, shall not be deported out of the country, or shall not be detained. Matter be listed after the tribunal records are received. Extra copies of the writ petition be furnished within the to the respondent councils within the course of this week.
Item 6.
Yes, party order. Interim tribunal order at 12, page 12.
It's an ex parte order.
Expired. Initially I appeared, thereafter I could not appear.
Mr. Sharma, come to page 28. You have been taking time in the tribunal that you don't have documents. Correct. Come to page 28. Now, this is not a certified copy, it's a downloaded copy from the internet. That means when you can do this, earlier you were taking time just for adjournment without any good ground. Where is the death certificate of your father?
No, that is not annexed. I could not collect it.
What is the date of death of your father?
Stop that.
And look at the remarks at page 29. Dr. Bikhoy Memon Tarikhor Namjari, Hukumate Dagor Swanso, Salat, Mafida Khatun Swanso, Namjari Kora Hol, registration deed, number deed dated 1170. So this is by way of purchase. Where is the deed of 1970?
No, annexed.
What is the age of the lady? The petitioner? What is the age? Because in the affidavit, I can't read it properly. It is 22.
Chip, in our affidavits, most of the times the copies are not complete. Nothing is written here.
You shouldn't accept it.
Shouldn't
Why?
accept it.
Actually, the clerks accept it and we
You
also.
instruct them.
Clerks are your agents. They represent you.
No, not, nothing, neither the paragraphs are mentioned, neither the mobile number, it's just a format, plain copy, and it's the government's copy, our copy too, we didn't find it only today.
No, when I was there,
Yes, Lordship.
if you can track any of the files, you will find that everything. No, where was there? My clerks would receive it, but everything would be complete, otherwise they will not accept.
That's what the rule says.
Lordship, so the copies are served, we are not there at that point of.
No,
time.
High Court rules are very clear on
You
this.
make your clerk run to the petitioner to fill up the gaps. Next time we'll do it.
We'll also do that.
You make them run at their own cost. go to their home, get it corrected, then you will, next day you will not find that complaint. So she is 22 years now. 22 years means she was born in the year 2000. 2000. How could she have a deed of 1970?
Page 23, Lordship. She has casted vote, Lordship.
We are asking you the age at page number 11 of the affidavit. What is the age of the deponent?
Writing is not very clear. It may be say 22, it may be 72, we don't know. What is the age of the deponent?
In your copy, have you written the affidavit? Let him serve a copy, complete copy. Lordship will take it up some other day. Lordship.
Give her a copy, otherwise you won't take it up.
I'll serve, Lordship. I have already served, Lordship.
The incomplete copy, Lordship. Nothing is mentioned
What
here.
is the age? What is her age? You are unable to tell us the age. What is her age?
Other day, Lordship. Other day, Lordship.
Because this is, we are reading it as 22. If it is 22, then Uttaraधिकारी Uttara, then they are referring to deed dated to 70. The death certificate of your father is not there. The sale deed is concealed. Therefore, there is no track. The documents are incomplete. And you have taken time, waited till you got the Namjari. After this mutation, then only you come to High Court. So that is the sequence. So the documents, why it is incomplete? Now, after getting a mutation and referring to deed of 1970, you can't say you don't have the document. The purpose of not putting the document is to conceal it. Which is a representative of the prayer made by counsel for the petitioner, list after a week.
Complete copy.
Item 7.
Let's please give us a complete copy, huh? This is also incomplete. They just
Your Lordship will find the interim order on page 65, Your Lordship. Your Lordship, it's quite a long order, Your Lordship. The petitioners, Your Lordship, exhibited certain documents of 1966. The
Now,
voter
how
list
have
of
you linked
19
it? Except for the evidence of your stepbrother,
Lordship.
what is the documentary evidence to link yourself to your father?
Your Lordship, Your Lordship, my stepbrother has exhibited a Jamabandi, Your Lordship.
Huh?
A Jamabandi copy, Your Lordship. And if Your Lordship.
Where is that?
If Your Lordship, page 38, Your Lordship. Type copy.
Page
38.
38.
And if Your Lordship peruse that copy, Your Lordship will find the name.
Just a moment. Page 38, yes.
Yes, Your Lordship. The name which are enlisted in the Jamabandi copy, Hasan Ali, Hikmat Ali, Farik Ali, Kismat Ali, then Messer Ali, my stepbrother's name comes. All these names are enlisted in the voter list of 1966, Your Lordship, and 1970. 1966 and 1970.
They are all there.
These names are there in the.
Shows that.
Yes, Your Lordship will, if Your Lordship may move on to page 66 of the voter list. Page 20, 2021. Your Lordship will see Sandhu Mia, that is my father's name, 21.
Hey, just a moment. Sandhu Mia is your father.
Yes, Your Lordship.
Yes.
Lal Mahmud is my elder brother. Hasan Ali, his name is there in the Jamabandi copy.
He is,
Asan Ali.
he is your brother.
Yes, Your Lordship. His name is there in the Jamabandi copy of it. Patrick Ali, Kismat Ali, these names are also present in the Jamabandi copy.
This is the voters list of
1966, Your Lordship.
and your name along with your parents or brothers and sisters.
Your Lordship, I got married before I attained the age of 18. Your Lordship, I had no birth certificate or school certificate, Your Lordship. Your Lordship, only thing I could do is I could rely on oral evidence, Your Lordship, of my family members, Your Lordship. Your Lordship, that's when, Your Lordship, my case get covered by Karim Ali and Sujab Ali, Your Lordship.
Karim Ali.
Karim Ali and Sujab Ali, Your Lordship. Your Lordship, I don't have the Karim Ali and Sujab Ali order. Your Lordship, I have placed
What
it
is the
earlier, Your
citation?
Lordship, that related to section 50 of the Evidence Act, Your Lordship. Where, Your Lordship, if section 50 of when the evidence or depositions of the family members becomes admissible under section 50 of the Evidence Act, Your Lordship.
Twenty-two 3 GLD 816. 2022 3 GLD 816. Yesterday, yesterday. Font size is to be increased. Ah. Para 51. Para 51. Yes. Notice Mr. I. Hussain for the petitioner. Notice opinion is at page 5. Page 5. Date of opinion and the case number. Extra copies within. Extra copies to the transfer to the respondents within in course of this week. Give bail to the satisfaction of bail to the satisfaction of
SP Border Borpeta.
SP Border Borpeta. Extra copies within Friday. Miss A. Verma for the Home Department. Ms. A. Fukan, CGC, and Mr. T. Sharma for the Government Advocate for the Deputy Commissioner.
Item 8.
The pleading lordship, my lord, this case decided on contest. My lord, the 66 voter list, my lord, contains grandfather's name, father's name. 70 voter list was also.
How have you linked yourself to your father and
My lord,
grandfather?
mother was examined. Mother was examined. Mother voter in 65,
Is
67.
which year?
My lord, DW2 lordship will find C at page
Page
68. C.
68.
Yes, my lord. Mother was examined.
No. Her voters is with your
My lord.
father and
Yes, my lord. In 65 onwards, my lord. At piece 40. Vernacular at 41. Mother's name Gabada Khatun. My lord, here and there, my lord, there are some minor name discrepancy. My lord, minor name discrepancies there with regard to father and the grandfather. Father, my lord. And those are picked up, my lord, by the learned tribunal. Mother was examined, brother was examined. Mother is voter in 1965, 65 onwards. Now.
please the cross.
Okay.
Notice for the records. Mr. A.R. Sigdar for the petitioner. Opening is at page 2. Give copies within Friday.
My
Bail to the satisfaction of Superintendent of Police Border, Gwalpara.
Corporate America. Golpara.
Is this matter on receipt of the trial court records, tribunal's records?
DPW.
Ms. Verma, look at the, you should read the cross-examination at page 73.
Even with every voters list, name change, village change, shifting is also there, Lordship.
No, but look at the cross-examination,
73.
73, I think. We'll take a break and come back.
Item 11 for admission.
May you please, your lordships?
Yes.
Look, as per order of last division, the petitioner was appeared before the SP, water SP, Duri, and took bail. On order 13/12/2021. My lord, kindly page 7, para 9. That the petitioner begs to state that he was born and brought up at village Balakuti, PS Tubangosh, district Kuzbihar, West Bengal. She was born on 1/1/1982, Exhibit 1. Got married on Mainul of village Maisha, part 2, PS Agumani district, Dhuri. And in this respect, a linkage marriage certificate dated 5/9/97, Exhibit 3, was issued by member Bhankumari 2, part 2, Gram Panchayat. Another linkage certificate has been issued by the block development officer, Tubangas 2, development block on 9/7/2015. Is it true? My lord, the copy of birth certificate is Annex 24, page 60. Linkage certificate dated 5/9/97 is page 61, 62. Annex 26, 63 and 64. My lord, linkage of the petitioner. My lord. My lord, the petitioner's father name was listed in the voter list 1966, 1971, and 1975. Lancet cell deed also, my lord, next step 4. My lord, the copy of notice dated 28/7/1965 is annexed. My lord, page 5, para 4. The petitioner begs to state that in respect of the said land, which is dated 28/7 1964 was issued in the name of her father, Sonaddin, due to non-payment of revenue. 3 years, Exhibit 5, my lord. A copy of notice dated Annexure 5. Annexure 5 is, my lord, is 2829.
What is your date of birth? Date of birth.
11/1/1982.
11/1 or 1/1?
11/1/1982, page 60.
Then
Birth certificate.
Birth certificate is there. Date of birth 1/1.
1. तो year लिखा है सर?
1. Page 60.
11/1/1. It was issued on 11.
My lord, kindly see page 10, para 14. May I read, my lord?
Just a moment.
D5. Then document 11. I think will be the same. Whether you still hold on to the letter. Saying that he failed to prove land documents related to her father.
Which page? Judgment to count.
Mother and brother. Must be a-
Tufan Ganj.
Mr. Sharma, what do you submit?
Apart from birth certificate, Lordship, there is document realized by the petitioner is not certified copies, Lordship.
What about the sale deed?
This is a sale deed of which was rejected. Doesn't appear to be a good ground.
Lordship.
And you see, these tribunals are passing the orders mechanically.
Yes, Lordship.
Absolutely no application of mine.
Yes.
The proceeding comes and says, I was born in 1982. An opinion of the tribunal is that his came into India post 25 3 1971.
Yes, Lordship.
The finding should have been the parents are foreigners and therefore she is not not born to the parents of Indian origin. 82 she is born. It's not a case that, it's not the prosecution case that she entered India after 25 3 1971.
Hmm.
I think you should recommend to the Home Department to have a
Lordship.
for upgrading their skills.
There are some judgment in respect of birth certificate, Lordship. So, Lordship, can it be on day after tomorrow, Lordship? Friday, Lordship, I will.
No, you forget the birth certificate.
Yes, Lordship.
But why the land documents are discarded?
Yes,
The
Lordship.
only ground is that the land document, present status of land was not shown. It is not not the foreigners tribunal's finding that the sale deed is not original.
Lordship.
It's a certified copy. But tell me, let us say you have an advocate's license.
Yes.
It was issued when?
Lordship.
It was issued on a particular year. Let us say that it was issued in 1995.
Yes, Lordship.
Correct. Now, can I discard that license by saying that your today's status, whether you are an advocate or not, that you have not given any proof? Therefore, I disbelieve your advocate's license issued in 1995. Am I permitted to say that? It is not the case that the names in the sale deed does not tally with the father's name.
Yes, Lordship.
Even if it is certified copy, let us say that X has the proceeding has produced a certified copy. And for some reason, they have sold that land.
Hmm.
Would that extinguish the existence of the sale deed? Come to page 126, para 1 and 2. You see the second paragraph. Name may be in the voters list, does not prove Indian citizen. Mother is coming and saying that I am 71 years. I am 80 years, 71 I voted.
Lordship.
Even in the last page, 125, last para, look at the ground.
Yes.
Now you see, now I'll just change the situation and then ask you the same question. You see, you had purchased a land. Correct? Now land was sold by A,
Yes.
purchased by you. Now, if this logic is applied, A loses title just because he does not give the present status of land. That means your ownership of the land is questionable now.
Yes.
I don't believe the title of A because he has not shown the present status of land. A comes and says that I have sold the land to Mr. Sharma. I don't believe the sale deed. And I say that your title is not there. Then what happens to your title? We are admitted for hearing.
Yes.
We admitted for hearing.
Day after tomorrow.
So we take it in the first week of September. We admit it for hearing.
Yes, Lordship.
Officers are represented. As the trial court records, as the tribunal's record is received. And in view of the grievance raised in the present writ petition, among these writ petitions is admitted for hearing by issuing rule returnable forthwith without requiring the petitioner to take fresh steps. Next, list the matter for hearing in the week commencing. Week commencing 9 September 2024. On the next date of, just say,
Well, next date maybe.
on the next date of hearing, the learned counsel for the petitioner shall inform the court as to whether the petitioner
September.
has appeared before the Superintendent of Police within bracket border, Dhubri,
My lord.
and
Please.
taken bail. After this, you write list the week commencing so.
My lord, next date, next date, my lord, 11 September, next date maybe saying I will be busy. Out of
After 11th,
11,
Commencing 16, 14.
week commencing 16 September.
Item 12.
highly available.
This matter may be taken up after some time, Lordship.
After some time.
Lordship, my senior is in another court. My senior is in another court.
Okay.
Item 13.
Lordship, a reference was made with regard to the petitioner in the erstwhile IMDT case. That reference was dismissed. That reference was dismissed. Thereafter, Your Lordship, this proceeding, impugn proceeding has been initiated, Your Lordship. But when this impugn proceeding was going on, Your Lordship, there was an order of this honorable court, Your Lordship, that the principles of res judicata won't be applicable in cases pertaining to foreigners' tribal. Thereafter, after Abdul Quddus, Your Lordship, the scenario changed. And Your Lordship, the petitioner approached the foreigners' tribunal by way of a review petition. That review petition was not entertained, Your Lordship.
Where is that? Which was the sequence?
Lordship,
The sequence, the orders?
Your Lordship, the law order of the IMDT, Your Lordship will find from page 38.
38.
The other thing, Your Lordship, the petitioner belongs from Bihari community, Your Lordship. He is a Hindi-speaking person, Your Lordship. And that is one of the reasons, Your Lordship, that has been. He doesn't belong from the specified territory.
But then there is again a difference of name. You are Ukil Ali and Akil Ali.
Akil Ali and Wakil Ali, Your Lordship, but the father's name is same, Your Lordship. That may be, Your Lordship, ascertain whether both persons are same or not, Your Lordship. That's a different aspect, Your Lordship, but this has not yet been entertained, Your Lordship.
Reference was dismissed.
Yes, Your Lordship.
Okay, then what happened?
Your Lordship will find the impugn order on page 62. This is the proceeding, this is the.
Page 52.
62, Your Lordship, annexure
62.
30.
No, then you said you approached the High Court.
Your Lordship,
You said that you approached the court.
yes, Your Lordship, that's a review petition, Your Lordship will find from page 67.
Page
67, annexure 40,
67.
No, after the IMDT order,
Lordship.
what order was passed?
After the IMDT order, Your Lordship, another reference was drawn against the petition.
That is at page 62.
Page 60. That is the order of the impugn proceeding, Your Lordship. But after Abdul Quddus was passed, Your Lordship, I approved the foreigners' tribunal. That there was other
Oh,
order.
acha, acha. Okay. Okay,
Since foreigners' tribunal did not entertain my petition, I approached this one.
rejected it.
No, it didn't entertain, Your Lordship.
What order was passed?
No order, Your Lordship. They said, no, we won't accept it.
Then you came before this court.
Yes, sir.
How did you, how have you shown that the records, your petition was not entertained?
Your Lordship, I have filed this application, Your Lordship.
Where is that application?
Your Lordship, annexure 14, page 67.
67.
Lordship.
This was not entertained.
No.
Not entertained means not accepted.
Not accepted, Your Lordship. But that you have come after a long delay, Your Lordship, so I can. The learned tribunal can't. Have this petition.
Against the order passed by the tribunal,
Lordship,
in respect of which you had filed a review petition,
Lordship.
you came before the court earlier.
No, no. No, Your Lordship, Your Lordship, I came, approached this honorable court after filing the review petition.
This
Before-
petition.
Yes, sir.
This is during what, which period was this file? What time? This petition, page 67, was submitted when?
Your Lordship, it was somewhere, sometime in the year 2019, Your Lordship.
2019.
Yes, Your Lordship. This order was passed in 2019, Your Lordship, 26/4/2019. Your Lordship, Abdul Quddus was passed in the year 2019 itself, Your Lordship, if I'm not wrong, Your Lordship. And in the year 2020, Your Lordship, this petition was filed. This is the. was the 30th day of December. 2020.
Mr. Sharma,
Yes, Lordship.
we'll again request you to talk to these people at home and have a email
Yes,
sort
Lordship.
of thing, because this,
Today itself I will communicate, Lordship.
you see, now we are in a situation where we don't know whether this petition was filed or not. But the petitioner has come to court and the petitioner is
Yes.
claiming that I went to the tribunal
Yes.
to file it, but the tribunal is not accepting it.
Yes, Lordship.
Your Lordship, the
No.
affidavit was notarized, Your Lordship, in
Huh?
on 30/12/19. The affidavit of this review petition was notarized, Your Lordship, by notary Sunitpur Tejpur. This petition.
No, but how do you, what material do you have to say that you submitted and it was not accepted?
Your Lordship, the thing is that when we approach, there has been many instances when we approach with some kind of application, Your Lordship, the Foreign Tribunal simply right away refuses, Your Lordship. They don't even allow the ticket, they don't even allow the first hearing, Your Lordship. There has been several instances, Your Lordship.
That is a mere statement. How do we act on that? There is no record in the tribunal. Tribunal records don't reflect anything. What is the period for review?
30 days.
30 days.
30 days.
30 days.
আহিছে accept করা নাই বুলি কৈ আছে
Do you have a copy which you submitted there? Tribunal?
yes 67
67.
Tribunal, page 2.
আর কিবা নোৱাৰে নহয়
Take instructions on this.
One instance.
The application is in.
Notary, yes, notary 30/12/2019.
Where is the, which paragraph is this statement that you went there?
Lordship. Yes.
Which paragraph is the
Yes.
statement in
Lot-
the
lot.
writ petition that you had gone there and the
Lordship.
tribunal did not accept it?
The Lordship will find on page 13, para 14.
Page
13, para 14. May I read it out, Your Lordship?
page 13.
Page 13, 1-3. Para 14. 1-3, para 14.
Yes.
That the petitioner begs to state that subsequently the petitioner preferred a review petition before the learned tribunal under order so and so of the Foreigners Tribunal Order 1964, read order 4 hereof and order so and so of the Code of Civil Procedure 1908 by enacting the citation of the Honorable Supreme Court, that is Abdul Quddus versus Union of India and others, where it is specifically stated the principle of res judicata equally applied to the quasi-judicial bodies. But the learned member most illegally and arbitrarily vehemently refused to entertain the review petition without assigning any.
Increase.
We'll show you something. See a copy of a writ petition. You see, this is also by a notary,
Lordship,
correct?
Lordship,
Each and every page of the writ petition contains the notary seal.
Lordship.
Now look at your annexure of that 62 or 67,
Lordship.
that petition.
Lordship.
Except for the affidavit, there's no notary seal anywhere.
Your Lordship, Your Lordship, in foreigners tribunal, only the affidavit gets notarized, Your Lordship, and the application doesn't get notarized. If I'm wrong, Your Lordship.
No,
No, Your Lordship, only the affidavit portion gets notarized. Okay. After it gets accepted, Your Lordship, then it has been signed upon the stamps and after it gets entertained, Your Lordship, it is accepted, Your Lordship. Thereafter, Your Lordship, the filing assistants, Your Lordship, from the filing sections, Your Lordship, they put signatures over those applications, Your Lordship.
Mr. Verma and Ms. Verma, in the tribunal, foreigners tribunal, the Shirstadar or the UDA is empowered as a oath commissioner
I think no,
to
Lord.
accept affidavits.
I have to take instruction as per
But Lordship, that notary seal has to be on each page, wherever it is.
No, we
Then
don't
we
know.
are-
You see, our counsel is making a statement at the bar. We don't know the procedure. So we are just checking up the LCR. Here we find this is how the evidence was taken.
Lordship may look into some other LCR also to.
You see this? Yep. We put a flag. By the Now, this is the affidavit of evidence on evidence on affidavit. Now look at the first page, the member is signing.
Yes.
Other pages, there is no signature. Proceeding is signed, but there is no signature. And the last page is the UDA who is
Oh, yes,
Accountant.
yes, Lordship.
doing it. So therefore, your statement that the notary must have a seal in each page is not the practice here in this tribunal at least.
Yes, Lord.
But I think this is a high time. There should be some order that the tribunals, if they don't accept a petition, then it will be sent to the email through email. And if they don't have an email, the lawyers will send it to the Home Department. Because if, what is the remedy if a lawyer goes to the tribunal? It doesn't fight, everyone doesn't fight.
Has a point there, but he's just making a statement. He doesn't have a copy of which he has submitted there. Maybe.
No, he has filed it. He says that the tribunal doesn't accept. You see, he went to the tribunal in December. Affidavit is sworn on 30/12. He says that I went to the tribunal and did not accept it. The writ petition was filed after 10 months in October. Correct. But the fact is that he gives a statement that I went to the tribunal and
Rejected.
tribunal did not accept it. The state does not deny that.
Lordship, it comes after such a long time, maybe it's.
No, I understand, but petitioner can't be disbelieved if he's making a statement before the High Court that I went to the tribunal, did not receive.
Lordship, is there anything in the records just to whisper that he came with the,
No, after 18, there is no order. After the opinion, there is nothing.
and when did the records come here? Was it after the records came here?
No, before that, this is a 2020 writ petition. He went in December 2019. Anybody in the
Maybe
court
some
who has,
valid reason, Lordship, I feel the tribunal, if it has not accepted, there may be some reason. Maybe he went after the time because his
no,
opinion.
that is okay, but dismiss it.
I will.
It could have been dismissed.
Yes,
You see, if I get a petition which is barred by limitation, what do I say? Not entertained, dismissed as it is beyond limitation.
Pass a order, Lordship.
Huh.
Yes. I mean, not accepted.
Anybody-
It has been passed also.
Anybody in this courtroom who has first-hand experience in appearing in tribunal? No.
Sikdar, maybe.
Mr. Sikdar, you have an experience in appearing before the tribunal? Foreigners tribunal?
Yes, my lord, but very occasionally, in some cases. my lord.
Okay. In your experience, any petition given before the tribunal, they accept it or they don't accept?
My lord, yes, sometime a petition return also. Sometime not accepted.
There are many instances, your lordship. I have also come across your lordship.
Is it?
Yes, my
Is your experience?
many cases.
No, it's your personal
In my
experience, sir.
case also. Sometime return.
Then what? Did you approach the Home Department by filing an application or before the registry of this court? Have you lodged any complaint saying that these are not accepted?
My lord. My memory, in one occasion I have lost complaint to the Home Secretary. Home Secretary,
You have lost.
yes, my lord. My lord, in one case, my lord, one of the tribunal member was called by this honorable court, my lord. Justice Honorable Sinta Molla Hussain Gura. Called the member of the tribunal of Kamrup Rural.
That was in relation to something else, not relating to not accepting documents.
Okay.
Because she used to report late, Lordship, so she was called and asked. And proceedings used to come from rural, Kamrup Rural. Since Kamrup Rural does not has an FD, the petitioners would come and wait and she would come late. So it was on those grounds, not on this ground.
You don't have a tribunal there in Kamrup rural.
We don't have one in rural. We have been, even Justice Bujor Bora had taken it up with the Home Department. A meeting was also called and DC had given an undertaking that they would open one there. But they have already located a space, but nothing proceeded after that. So all the rural cases, Kamrup rural cases are now being conducted here in Ulubari.
Do you have a copy of that order?
Actually, order was supposed to be passed, but the home officials came, even the chief secretary had come, home department, all the top people had come and we had a meeting there in the chamber. We were also present.
Please take up the follow-up, what follow-up action has been taken and apprise us. There are cases.
Two cases.
You just tell us a field situation.
Lordship, after that, I had asked once or
No,
twice to
we
the
are not,
department, but
no, Ms. Verma, we
I
are not,
didn't get any
no, no,
satisfactory.
we are not asking a response right now. You take it,
No order was passed. He called them, he told them that this is the difficulty the proceedings are facing. So, one further
no,
tribal
no,
court to be then
see, I'm
coming
not
up.
questioning you. We are not questioning you. What we are asking is that if you can interact with the home people and give us the updated status, then we'll
Those
think what to do.
officers have Also been transferred now.
Huh? Okay.
Those
So
officers
the
have,
department is there. somebody
department
should
is
be there.
there, yes, Lordship.
Just try to interact with them. We don't want to answer right now. Monday, you can just take your time and then interact them
You
and tell
find
us.
out and tell us which districts there are no tribunals.
As far as my knowledge goes, Kamrup rural is the one where we have lot of difficulty because people come from very, very remote places and they all have to come to Ulubari in the absence of a tribunal there.
No, that's okay.
And
Mr. Ram,
this
we
matter
are,
has been taken up number of times, Lordship, with the government.
no, that's okay. We are not questioning you personally. What we are asking that you can interact with the home department and tell us on Monday what is the situation. Then perhaps we'll discuss within ourselves to think of our
We'll
next
try
course of
to,
action.
Get in touch. I cannot promise, Lordship, but we'll definitely try.
Trying is enough, good enough.
And regarding this, huh?
One
नहीं, rural case को लगभग तो जाते हैं IPS से। देखा नहीं? Sure, active rural 9, coming out 9. We did receive a list.
Yeah, we could be maybe tribunal with the timing. Friday, except his take.
It is for one. Yes.
Once some of them
Thing to produce the judgment. But it remains well after. Judgment process.
Lordship, we have a list of the FTs. We'll try to get the latest one because here there was one there where one of our members was there, but she passed away. After that, we do not have no idea who's there. But the rural one was here in Ulubari, Lordship.
Total 5 tribunal lordship.
We have 5 in Kamrup.
Kamrup rural.
Rural.
In Kamrup rural,
Yes, lordship.
but all here in the vicinity of the.
I have a list,
metro.
lordship. I will provide to the court master.
No, these,
ये तो लिखा
where
है,
are the tribunals situated?
Yes, lordship, that was not mentioned here. Lord.
Okay,
but that member was called relating to this.
No, personally, we
Lordship, we'll
don't,
get this
personally,
information.
we don't want to call anyone.
We'll get it
Personally, we
from
don't
the
want to
Home
call even
Department.
the home people. We don't want to call
Yes,
it.
Lordship.
We are just collecting information. Then we'll see what we will. Ms. Rama, we are in
Yes,
two
Lordship.
thoughts. In this case, we are in two thoughts.
Yes, Lordship.
A petitioner comes to court and says that I went to the tribunal and did not accept it. Now, if it is not accepted, there can be no proof that it has gone. Now, today, if you question the court and the staff, they will never accept that the petitioner had come there. Correct. So this is situation one.
So, Lordship,
Huh?
we may not remember, it's 5, 6 years now.
So that is one part. The second part is that even if we send them now, question of limitation is again there.
But it ought to have been taken in an order passed at that point of time. That it ought to have been taken if he had approached the tribunal. Then if an
but
order
the
was
law is
passed, it
settled.
would have made it easier
the-
for this court.
But the law is settled.
Yes.
Question of law is well settled. Once is that a tribunal res judicata would apply.
Lordship can grant him that liberty now, let him go and file it.
It is issue to settle him.
Lordship may give the petitioner a chance to make a fresh application and the tribunal to decide whether res judicata is, principle
Okay,
of res judicata is
We'll
applicable.
come
or
back
not.
at 2 o'clock with a fresh mind. We'll
Lordship,
come back at 2 o'clock with a fresh mind
Lordship,
and think over. This, what is the financial status? They are well-to-do people, this petitioner?
No, they are not that well to the such people here. They are Hindi speaking people here. They are Hindi speaking people. They belong from Bihar, their roots.
What is the petitioner doing?
So Lordship, they do petty jobs, your Lordship, sometimes labor, sometimes in small shops. So they're not that well to do people, your Lordship.
Nice.
Anything to submit more, Mr. Sharma?
Issue of res judicata was earlier settled by this honorable court. In the case of Amina Khatun versus Union of India, I have copy has been given to Court Master Lordship. So Lordship, it was pending before the Supreme Court, Lordship, without having any stay order, Lordship.
This is pending.
Yes, Lordship, before the Supreme Court, Lordship.
What was held here?
Then, by challenging this order, Lordship, some petitioner approached the Supreme Court.
It has already been clarified in Abdul
Your
Quddus.
Lordship, this was prior to Abdul Quddus, your Lordship. This was prior to Abdul Quddus.
But
Subsequently, Abdul Quddus is there.
After Abdul Quddus, your Lordship.
subsequently, Abdul Quddus is there, Lordship, but that issue is already pending before the Supreme Court, Lordship, in respect of Amina Khatun's case, Lordship. So, Lordship,
No,
let
we
it
may
come
not,
up for
we may not comment if the Supreme Court wants to give a different opinion here.
No.
But as on date, that Abdul Quddus,
yes, Lordship.
that is the
true,
law laid down.
Lordship, and Lordship.
And this would be in view of that Abdul Quddus citation is.
Your Lordship, there are several orders passed
Abdul
by.
Quddus, what is the citation?
Lordship, Abdul-
2019.
Lordship. Okay. Give those a second.
That's, this, Abdul Quddus were decided on 17/5/2019.
Yes, Lord.
This is prior to that, so it is prospectively overruled. The appeal filed by the parties is
Lordship.
otherwise infructuous in view of the Abdul Quddus, which is decided by a full bench.
And your lordship, subsequent to this, your lordship, after Abdul Quddus, this honorable court has interfered in lots of cases, your lordship.
No, no. Following the Supreme Court judgment, what we are, that is not the question. Here he is raising a issue that the decision of this in the 7/339 is challenged before the Supreme Court of India.
Yes,
But during the
This is-
pendency of the challenge, Abdul Quddus has come by a full bench.
but still now it is pending, Lordship.
No, no. You know the
Yes,
principles.
Lordship, I have understood, Lordship, but in another.
Para maybe plus minus here or there. Para 28 or 38, I forgot, of Pranay Sethi.
Yes, Lordship has on earlier occasion.
That
And
is-
Lordship- My another submission is that Lordship, our High Court in several occasions, Lordship decided, Lordship, if earlier order is not a reasoned one, then principle of res judicata is not applicable, Lordship. One of that case is, Lordship, is Rafiqul Islam, Lordship.
No. You see, shows that.
Your lordship, one such order was challenged in the Supreme Court, your lordship, whatever I come to know, Supreme Court has stayed that order, your lordship.
Unless you give us the correct citation. Or the case number, even if you give the case number now, we can find it out.
Where is the provision for review?
Lordship, Lordship. Foreigners Tribunal Order 1964, Lordship.
That's 64 to 9.
Order 381. Order 381.
Lordship, Order 382, Lordship. A2.
Foreigners Tribunal Order 1964.
Still a part of the regulatory strong procedure.
You hand over that book to us. We appellate. What we did. Where we did. Fundamental back. Separate order. That's the wall. That we use it. Okay. Exactly. Okay. Remember. We propose to interfere with this order and remand the matter back. And the tribunal is directed to pass the order afresh, taking into account the findings of the IMDT. What is that IMDT? IMDT order, which he claims has already been passed. But you have to tell us whether this IMDT order, was it interfered with? There is a list of cases
Yes, Lordship.
where the orders were interfered and transmitted back to the Foreigners Tribunal.
Yes, Lordship.
Is this a part of that list?
I have to take instruction.
How long will you take? Can you do it in the course of the day today?
Lordship, next Monday, Lordship.
Monday to Tuesday. Then we'll have it on Tuesday.
Lordship.
Let him make the verification and then we'll have it on Tuesday.
Lordship.
Senate Counsel for the parties. Petitioner is aggrieved by the impugned order. Opinion dated 26/04/2019, passed by Learned Foreigners Tribunal 7th, Tejpur at Balipara in case number FT within bracket IMDT 259 of 2016, whereby the petitioner was declared to be a foreigner. Where is the impugned order?
Your Lordship, on page 62, Your Lordship.
Of post 25/3/1971 and answered the reference accordingly. Stop. The writ petitioner is before this court with a specific prayer that in view of the judgment of the apex court rendered in Abdul Quddus, reported in so and so, a review application was filed before the tribunal. Where is the application?
Your lordship will find on page '67.
19, 6 SCC, 604. Where is your review application?
Your lordship from page 67.
67. Petitioner claims that this review application was filed on or about, was presented before the tribunal on or about December 2019. Stop. It is submitted by the learned counsel to the petitioner that this application was not accepted by the learned tribunal and no orders thereon were passed. Left with no alternative, the petitioner has approached this court. Stop. Para. It is submitted by the learned counsel for the petitioner that earlier, by order dated 22/12/2004, an order was passed by IMDT in case number 208. And LSC number TZ so and so, page number 38. Please copy. Learned counsel, referring to the said order, submits that the IMDT tribunal, by the earlier order, had returned a finding that the petitioner was not a foreigner and the reference was dismissed. Stop. It is submitted that this order came to the knowledge of the writ petitioner subsequent to the order passed by the tribunal impugned in the present proceedings. And consequently, a review application was filed which was not entertained or accepted by the tribunal. Stop. Under these circumstances, appropriate orders are being sought for from this court. Para. The respondents, represented by the learned counsel so and so, is permitted to obtain the instructions as to whether the order dated 22/12/2004 passed in IMDT case number 208 and LSC number so and so, by which the reference against the writ petitioner was dismissed, is still holding the field and was or was interfered with by this court in a series of orders which were passed in respect of certain orders passed by IMDT tribunals. Stop. Learned counsel for the respondent submits that he would like to complete his instructions and prays that the matter be listed on on Tuesday. Accordingly, let the matter be listed again on 20/08/2024.
Lordship, the facts and circumstances related to item number 13 and 16 is similar. Here's the item number 13 and 16, the facts and circumstances are similar. Actually, he's the brother of the present petitioner. So it may also come up with this item number 13 and 16.
Let us see 13, 16, 16.
Lordship. Therefore, your lordship, there was an order of the IMDT, your lordship, and subsequently a review petition was filed, your lordship.
Here also, did you file a review?
Yes, your lordship, from page
Paragraph?
69.
Item 16 single, so to be listed together on 20. Mr. Sharma, please get the instructions,
Yes,
note the matters. It's review library. Printed by lead. By law. So therefore, the doctrine of litigator will have to be applied. But this is not, there is no finding that is on the presumption that there could be materials in favor. But can we come after the Yes. But
Item 42, fixed at 2 p.m.
That. I file IM for inclusion the FP case number, that was inadvertently not. Just to go to the same bench. I am not kindly similar to page 9. Like, sir.
pending is it?
Correct, sir, A.
কোন অপশন রিকুইজিশন এখন লিখি থেকে হয়ে গেছে আমি বলেছি আর দুটা কপি আছে দুটা কপি দিব
Normally to say
দুজন দাস বই
normally
টু কপিস বলি লিখে দিব
We are directing the registry to list it before the same bench.
There you go.
Okay.
Timing goes on.
For the, we are adjourning for the time being. Let us examine after some time.
Item 46 to 51 fixed at 2 p.m.
Yes, my lord, 48 item.
Just a moment. Mr. Das. Uh, you have any objection to this? You have checked this paper book, it's okay? The deposition of the witnesses are there.
My lord,
According to you, it is okay?
but I am not furnished with that position.
Okay.
That is compilation by,
One idea.
that is perhaps compilation by senior counsel.
254, criminal appeal 254.
Yes, 254. Two 54, item number 46.
Uh,
So,
Mr. Bhuyan,
Yes, my lord.
we're asking for that because of the fact that the registry has given up a note that they need further
Right.
3 weeks time to prepare the paper book.
Yes, my lord.
It is incomplete.
But in my
Because
petition, my lord,
Mr. I think this is 254 is by Mr. H.R.A. Chaudhary.
yeah,
Yes.
He has given this
He-
paper book.
he's in on legs,
No,
my lord.
no, that's not the point.
Yes.
The point is that if we are relying on this evidence, whether this is correct or not, because we have not examined that.
Subject to
That
verification
has
by
to be
the registry.
verified by the registry, my lord, paper book section, my lord, with comparing with the original one. My lord. And after it is okay by the my lord, translation department, then we can rely.
Because we were thinking that if you can have a copy and then you can examine, or because if we send it for the for verification, by that time 3 weeks they will prepare the paper book.
Yes, that can be. So
Because
for,
we understand that this is a bail application.
Yes.
The adjournment is not in a not appreciated, but the fact is that if we are relying on the set of evidence, we have to be confident that this is
absolutely.
correct.
Right.
That is why we were discussing and thinking how to go about with it.
Yes.
Because if somebody verifies vouches for the correctness, then it's okay. Because if we have to compare it,
Yes, somebody has to authenticate it. One word here or there,
It will be the same set of evidence for all.
same set of evidence, my lord, common judgment.
2 weeks time to verify.
Hmm.
If this is not in April, 3 weeks, 3 months is in. By this time. we will make a visit
next week, after week,
next week.
what we are proposing is, we, uh, my brothers also suggested, we give them 2 weeks time to prepare the paper book or to verify the correctness of this and come back.
Yes, yes, that will be better.
So for my matter is concerned 48, my lord, that we have taken the juvenility ground.
Oh, juvenility ground.
Yes, that's altogether different footing, my lord. For that purpose, I have made my submissions with regard to this. The birth certificate issued by the Assam government has been annexed. That's been a document. Now, this incident took place in the year 1999, and 29/6/1999. And at that time, Juvenile Justice Act of 1986 was prevalent. Now 2000 Act comes into. Now what will be the law? That time it was 16 years. Now it's become 18 years as per 18. That has been made by the Supreme Court also, my lord. And even the Juvenile Justice Care Protection Act 2000, the saving clause itself speaks in volume with regard to this, section 39 of that particular act.
Juvenile Justice Act. Juvenile Justice Act. Even protection. Oh, acha, huh.
What is your item number?
48, my lord. 48, huh? Yes, 48. Juvenile justice.
No, in this, Mr. Bhuyan,
Yes.
in this case, there is also a judgment which says that it is the date of the crime which is
Yeah.
material.
Yes.
The law which is prevailing on that day
Yes.
will be applied.
No.
applicable.
There is a recent judgment. That's what my lord is, I was, yeah, it was there. This has been a judgment 2021 SCC online, 3359, my lord. 7A has been discussed because 7A has been incorporated in the year 2006. Now, if your lordship allow me to read paragraph 8, 7 and 8 and 9, it will be clear. What will be the law prevalent? Seven, if your lordships look into it, under the 1986 Act, the age of juvenility was up to the 16th year. 8, my lord, this 7A has been introduced, has been quoted. Now 9 can we come to 9?
The claim of juvenility can thus be raised before any court at any stage, even after final disposal of the case. And if the court finds a person to be juvenile on the date of commission of the offense, it is to be forwarded to a juvenile to the board for passing appropriate orders, and the sentence, if any, passed by a court shall be deemed to have no effect. 10. Even though the offense in this case may have been committed before the enactment of the Act of 2000. Here in this case, it was the judgment was passed in 1987. It appears to be 1997. The petitioner is entitled to the benefit of juvenile under 7A of the Act of 2000 if on inquiry it is found that he was less than 18 years of age on the date of alleged offense. Am I clear, my lord? So this act will prevail. And in view of, my lord, it appears because of that saving clause, my lord, it appears 39, 42 at the, I'm looking into it, sir. That is the saving clause because of that. This law has been very clear on this point.
111 or something.
My lord?
111 or something, savings clause.
Yes, my lord, 39, 2000 Act, my lord, I am talking about the 2000 Act. 39. 40. Rules from something. 69, I'm sorry. The Juvenile Justice Act 1986 is hereby repealed, notwithstanding such repeal, comma, anything done or any action taken under the said act shall be deemed to have been done or taken under the corresponding of provision of this act. So this act defines juvenility age under 2K, my lord, to be 18 years. Previously, it was 16. That benefit has been given to this act also. And my humble prayer with regard to, my lord, a direction to the district judge, my lord, to make an inquiry with regard to ascertaining the genuineness of this certificate, my lord, and that's all. And if a report comes in, this is a genuine certificate, my lord, the case has to go to the juvenile board, my lord. Mm-hmm. 2024, there is another judgment, my lord, did you? Copy to did it? Ah, yes, yes. Asset.
Yes, my lord.
My lord? Yes, another just 2024, did they copy? Honorable Justice B.R. Gavai and Sandeep, Justice Sandeep. My lord. Paragraph 7, my lord. May I read it, my lord? Even in the appellate before the High Court, a pertinent plea was raised on behalf of the appellant that he was a juvenile on the date of incident and the proceeding undertaken against him in the trial court were retreated. However, the High Court has also failed to ever to the said prayer in thus argued that an inquiry should be directed to determine the age of the appellant so as to decide the plea of juvenility as per law. Now, paragraph 10, my lord, indisputably during the pendency of the appeal before the Patna High Court, the Juvenile Justice So-and-so Act of 2015 that come into force whose provide a comprehensive mechanism to consider prayer of the juvenility raised on behalf of an accused claiming to be a child on the date of commission of the offence. The provision of section 9(2) of the said Act clearly enumerates that plea of juvenility may be raised before any court and it shall be recognized at any stage, even after final disposal of the case. The High Court, however, did not consider and decide the prayer of juvenility raised on behalf of the appellant. Paragraph 12, my lord, the guidelines laid down, my lord. 39.2, my lord, is important for my case. For making any claim with regard to juvenility after conviction, the claimant must produce some material which may prima facie satisfy the court that an inquiry into the claim of juvenility is necessary. So the birth certificate itself was. And in the 313 also, my lord, he stated to be a juvenile. My lord?
Birth certificate is at page
Yes, my lord. In my IA that I have filed, I found that.
87 IA number.
IA number 2, 387. Sorry. That is at page, my lord. 91, my lord. 92, I'm sorry, 92, my lord.
now. Under the Assam birth and certificate, birth and death registration rules,
Yes,
if the birth is registered after a year,
yes.
then there has to be a order of the magistrate.
Now it is there. This certificate has been obtained in, my lord, 2016.
No, no, it's
Yes.
far beyond 16. This is the Assam births and deaths registration rules. That amendment came long back. Because privacy, if we are required to give a privacy satisfaction,
Yes,
then the division bench has laid down the law.
yes. That's the Supreme Court also, my lord. Even in a case, my lord, with regard to considering the demeanor of a particular accused persons from what strata of the organic whole he belongs to, even there may not be any document. In that case also, if a plea has been taken, the court has to look into, my lord. Because there are
No,
certain.
but you are showing a judgment that there must be cogent materials before
My
the
lord?
court. This, the paragraph which you read.
Birth certificate is a, my lord, relevant document.
No, it's a relevant document.
Yes,
But as per the judgment of this court,
yes,
unless it is accompanied with with the order of the magistrate,
my lord.
it is not a good document. Can't be acceptable. But there's a division bench saying that.
But 2016, whether that law was prevailing, my lord, that will be the important question. If any amendment has been made, my lord. And even then, my lord, the best way out is ossification test. 2 years here or there, my lord. Judgment. Rely करनी पड़े. First made birth certificate, second this, third
At the
this.
time of commission of the offense.
Yes.
Which act was prevalent?
1986.
And
Because
there-
occurrence took place in 99, my lord. Juvenile Justice Care Protection came in 2000. Amendment was made in 2006. So 7A was incorporated, my lord. And so, my lord, that particular judgment, I place it before the court, that it will cover that also, my lord. Because of the 39, my lord, the saving clause, 69, the saving clause. Saving clause 2, my lord. Anything done under that act would be considered to be under this act. And under 2000 Act, my lord, juvenile